connection.
I don't know. I've sent the link. I've sent the link to you. Did you receive it? Yes, about to deliver. We are waiting for you. Yes. We are waiting for you.
For me?
Yes.
I don't have my weekend down with you.
Come online, please.
I should come online?
Yes.
Okay, it's this one.
Yes, I'll forward the link to you. I've texted the link to you.
Who is that one?
There's another matter, Barrister Afolabi Olayiwola.
Okay.
The customer you're calling is currently not reachable. The customer you're calling is currently not reachable.
Who is that?
It's the same person, Barrister Afolabi Olayiwola.
No, you can get, but you sent notice to him.
Yes, ma'am.
Was it acknowledged?
No, he didn't reply my text message. But I forwarded it to his.
Are you sure it reached him?
Yes.
To copy this tune, press 1. The customer you're calling is To copy this tune, press 1. The customer you're calling is not.
Barrister is it? Who's Barrister is it?
That's the person I'm calling now.
She is connected now.
This one is Easy Afolabi. Easy Afolabi.
Is it Afolabi?
Yes.
Okay. Any representation for the defendants? Any representation for the defendant in NUT and others versus ASUS and others? I can see the name Barrister Eze there. Can you hear us? Barrister Eze? What about the other lady?
She says she's trying to link the Zoom.
Well, I think we need to proceed. I know that counsel to the claimant has been waiting. So this is my judgment. We'll start and they'll follow up. These are network issues. That is why it is like that. First of all, we are starting with the court decision on the preliminary objection. The first and second defendant's preliminary objection is premised on 3 grounds: that this suit is incompetent and liable to be struck out, the claimants not being members of the first defendants, not being members of the first defendant have local standard to interfere on the relationship between the first defendant and its members, and demand to see, verify, and authenticate list of the first defendant members before the said list can be used to make deduction on behalf of the first defendant. And 2, the suit is an abuse of court process and academic exercise because of the amicable settlement reached by the parties on the issue of deduction of levies for the first defendant based on the general payroll of the teachers before filing this suit. I will take these grounds one after the other. In considering the merits of this case, I start off with some preliminary points in the processes filed by the parties. The defendants referred to 4 unreported case law authorities without as much as providing the certified copies of the said judgments, contrary to Order 45, Rule 3, Sub-Rule 1 of the rules of this court, NICN Rules 2017. The 4 decisions are Comrade Oyeneni and 12 others versus Kalama, John Tompre, and 3 others. Mr. Charles O. Chioko and others versus the head of service, Enugu State, and others. Non-academic staff union of educational and associated institutions, that is NASU, versus Jacob A. Ania Jacob A. and 2 others, and Nigerian Union of Teachers versus Comrade M. Anigala. As her ladyship, Augie, JSC, put it, Major General Kayode Oni, retired, and 4 others, versus Governor of Ekiti State and another. It is an elementary principle, very elementary, that counsel who wants the court to make use of authorities cited in court must provide the name of parties, the year the case was decided, and where the case was reported, name of the law report, the year, volume, and page must be cited. But if the said case is unreported, counsel must provide the court with a certified true copy of the judgment sought to be relied upon. Sichidoka and another versus First City Financial Company Limited, and the citations are in the judgment. Wherein Galinje JSC stated, where counsel cites a case that has not been reported, he owes the court a duty to produce a copy of the judgment if he wants the court to rely on such unreported authority. The said authorities cited by the first and second defendants shall accordingly be discontinued for purposes of this judgment, as they were not submitted to the court, being unreported cases. I stated earlier in this judgment that in their reply on points of law, the first and second defendants referred to the case of Race Auto Supply Company Limited and others versus Alaji Farsad Akir, Pel Mohammed JSC, without more. On the purpose of citing a case, Supreme Court heard in the case of Izeze and Enoch versus Enoch and others, Perot's rival, heard that, quote, a case is an authority for what it decides. Relying on a case without relating it to the facts that induced it will amount to citing the case out of the proper context. The whole purpose of citing a case is for the law on it to be known. See also Mr. Philip Shagba Ibado and another versus Keystone Bank Limited and Tempe Global Service Limited and another versus Ifani. The citations are in the judgment. The first and second defendant's written address is in support of notice of preliminary objection, brings once again the need for counsel to improve on their drafting skills. Drafting is an important tool of advocacy.
This is not my judgment. Let me get
And the need for a mastery of the act of drafting by a lawyer cannot be overemphasized. An otherwise good case can be lost by inadequate drafting skills, as the very foundation of every case are the processes presented to the court for adjudication. Most especially important is keeping to tenses of the English language, such that the entirety of the address replete with SIC, S-I-C, all through. In Hamza Yahya and another versus Ibrahim Mohammed Fari and another, the Court of Appeals, speaking on the necessary drafting skills the counsel must possess, said in Score Nigeria PLC versus Danbatten. Drafting is an important tool in advocacy. A solicitor who could not present his client's case clearly in the brief, if it is a case in the appellate court or in the pleadings, if it is in a case before the High Court or Federal High Court, could not adequately represent the interest of his clients. An otherwise good case is destroyed and lost by bad pleadings. Counsel should pay more attention to drafting, as no counsel could be good and make marks in advocacy if he is poor in drafting mechanism, close of quote. It is hoped that counsel to first and second defendants will take proper steps to improve on their drafting skills and to be mindful when preparing a brief of arguments, minding especially spelling errors and keeping to tenses. See also Umage versus Commissioner of Police, Ogun State, Adeleke versus Adejumo, Ibrahim Shekarau versus Federal Republic of Nigeria. Citations are in the judgment. The first ground of objection is that this suit, as constituted by the claimants, is incompetent and liable to be struck out. That the claimant had repeatedly and categorically stated in the paragraphs of the affidavit in support of originating summons and further affidavit that the first defendant they brought to court is an unregistered body, and the first defendant was sued in its unregistered name. That the law is clear that non-juristic person cannot sue or be sued. Cited Duana versus Ibrahim and others, and Maersk Line and another versus Adide Investments Limited and another. On the basis of the claimant's reported ipse dixit, first and second defendants peremptorily urged this court to head that this action cannot be maintained by the claimants against the first defendant, as the suit is incompetent and liable to be struck out. It is not in doubt that the task of interpretation of laws and documents is judicial. The claimants, in their reply on points of law to the first and second defendant's preliminary objection, maintain that they have the local standard to enforce a legal right in court, and it could be by way of asking the court to interpret a judgment. Cited Nigerian Seafarers Collaborating Union versus Nupeng and another. And there are other case law authorities in this court on the issue. For instance, Mr. Kindele Idigbe versus Oracle Software Nigeria Limited heard that the task of interpretation of laws and documents is a judicial function, not an executive one. And, quote, a circular cannot override statutory provisions, close of quote. On the cardinal rule of interpretation of instrument, document, or agreement, the Supreme Court heard in Mbani versus Bossi and others that, quote, it is settled law that in interpreting a document or judgment, the document or judgment must be read as a whole and interpreted in that light, with effort being made to achieve harmony among the parts. See Akaya versus Idama, close of quote. In Atilade versus Ojo and others, the Court of Appeal heard per Abiru JCA thus. I'm quoting Abiru now. In Attorney General Lagos State versus Attorney General of the Federation, Supreme Court made the point thus, quote, when a preliminary objection is raised in an action such as the present one, commenced by originating summons, it is always better to take preliminary objection with the substantive case, so that if the objection succeeds, the case or action is terminated in limine. If the objection fails, however, then the court will proceed to determine the substantive action on its merits, close of quote. So whether this suit is incompetent and liable to be struck out will be determined along with the originating summons of the claimant's respondent's originating summons. I so rule on issue number 1 of first and second defendants. Regarding issue number 2, it is submitted that the claimants, not being members of the first defendant, and they were not given the powers to verify and authenticate list of members to make deduction on behalf of the first defendant in the consent judgment. The claimants lack the local standard to challenge the first defendant's list of members, and this court lacks the jurisdiction to entertain this matter on that ground. In support of their argument, the first and second defendants cited the case of Yesufu versus Governor of Edo State and others. Citation is in the judgment, and it states that plaintiff, to enable him evoke the judicial power of the court, must show sufficient interest or threat of injury he would suffer. See also Sehindemi versus AG Lagos State and others. The citation is in the judgment. On local standard and what a party must show to establish local standard and how the court determines them and the effect of lack of local standard on the jurisdiction of the court Court of Appeal heard in the case of Gaidam versus Moses and others per Ige. JCA does. I'm quoting Justice Ige now. The settled position of the law is that a complaint that plaintiff lacks local standard to institute an action is interwoven and intertwined with jurisdiction of the court, called upon to adjudicate on a suit lack of local standard and intertwined with jurisdiction of the court, called upon to adjudicate on a suit or action. Lack of local standard to sue robs the court of jurisdiction to embark upon adjudication over the reliefs and the matter and the reliefs sought therein. See Alaji Saka, Pobi, and another versus Laiwola Muniru. Citation is to the judgment per Adekeye JSC, who said, locus, I'm quoting Justice Adekeye now, JSC, retired. Local standard is the legal capacity to institute an action in a court of law, where a plaintiff is held to lack the local standard to maintain an action. The finding goes to the issue of jurisdiction as it denies the court jurisdiction to determine the action. The rule about local standard courts from being used as playground by professional litigants or and meddlesome interlopers, busybodies who really have no real stake or interest in the subject matter or the litigation, close of quote. As rightly submitted by the learned counsel to the parties in this matter, claimant will have local standard to sue if he is able to show or prove that his civil rights and obligations have been or are in danger of being infringed or jeopardized. Therefore, in order to determine issue of local standard, the court is enjoined to confine itself to scrupulous examination of reliefs sought on an originating summons and affidavit in support, where the action was commenced by originating summons or originating motion. The case of AG Federation versus AG Lagos heard that, quote, also settled is the principle of law that in order to determine whether a court before which a matter pens has the jurisdiction to entertain them, the court has to look at the plaintiff's statement of claim before it and not the defense put forward by the defendant to the action. The claim of the plaintiff in an action includes the originating summons and the affidavits in support of same, where the action is instituted. Any originating summons as was decided by this court in the case of Inakoya versus Adeleke. The citation in that quotation is in the judgment. As the law stands, by Giadon versus Delemoses and others, only a consideration of the claimant's originating summons and the affidavit in support of same would determine the claimant's locus standi in this suit. Regarding issue number 3, first and second defendants submitted that from the amicably settlement reached by the parties on the issue of deduction of levies for the first defendant based on the general payroll of the teachers before filing this suit is an abuse of process of court. Senior versus Noah and Chief Shodipo versus Lemi Kanyip and another. Citations are in the judgment. On the meaning and nature of the concept of abuse of court/judicial process, the Apex Court heard in Oyeyemi and others versus Owoye, per Onogen, JSC, later CJN, thus, it is settled law that abuse of process contemplates multiplicity of suits between the same parties in regard to the same matter and on the same issue. And in Adebanke versus Ojalabi and others, the Apex Court heard per Kekerekun, JSC, thus, quote, this court heard in African Reinsurance Corporation versus JDP Construction Limited, per Nikki Toby, JSC, thus, quote, where a party duplicates a court process, the more current one, which results in the duplication, is regarded as an abuse of the court's process. Abuse of the process of court is a term generally applied to a proceeding which is wanting in bona fides and is frivolous, vexatious, or oppressive. Abuse of process can also mean abuse of legal procedure or improper use of legal process, as in this case. Thea Mefule versus the state. An abuse of process always involves some form of bias, malice, and some deliberateness, some desire to misuse or divert the system. See Edet versus the state. There is said to be an abuse of the process of the court when a party improperly uses the issue of the judicial process of the court to the irritation and annoyance of his opponent, such as instituting a multiplicity of actions, the same subject matter against the same opponent, the same issue as in the instant case. See Okafor versus Attorney General and Commissioner for Justice, Anambra State. See also versus NV Ship versus the MVS Arabs. The citations are in the quotation. To the first and second defendants, what the claimants, respondents want from this court is to read into the terms of settlement is to rewrite or read into the consent judgment the terms the parties did not agree on. Only a determination of the substantive matter, that is the originating summons, can lay to rest the issues propped up in the preliminary objection that could at best be treated in the suit. On the whole, I'm satisfied that this suit was appropriately commenced using the originating procedure. Accordingly, I hold that the suit is competent. As such, this court has jurisdiction over it. On the whole, there is no merit whatsoever in the preliminary objection of the first and second defendant. It fails, and so is hereby dismissed. I now turn to the merit of the originating summons. The merit of the originating summons throws up a number of issues, including some preliminary ones. Order 45, Rule 3, Sub 1 of the National Industrial Court of Nigeria, Civil Procedure Rules, stipulates that where any unreported judgment is relied upon, the certified true copy shall be submitted along with the written address. And in Major General Kayode Oni, retired, others, this is Governor of Ekiti State and another, this is what Her Ladyship Augie JSC said. It is an elementary principle, very elementary, that counsel who wants a court to make use of authorities cited in court must provide the name of parties, the year the case was decided, and where the case was reported, name of the law report, the year, volume, and page must be cited. But if the said case is unreported, counsel must provide the court with a certified true copy of the judgment sought to be relied upon. What all of this means is that first and second defendants do not want this court to use the case of Attorney General Kano State versus Attorney General of the Federation and the case of Nigerian Union of Teachers, NUT, versus Comrade M. Anigala. or unreported suits, the judgment of which was delivered on 2nd December 2014. The said cases shall accordingly be discountenanced for purposes of this judgment, and I so hold. In paragraph 13 of their sworn affidavit in support of originating summons, the claimant stated that as the matter of check-off dues seemed unsettled, and it seemed that the first defendant was being granted an necessary audience by the Delta State government, the claimants filed an action in the Enugu division of this court, in suit number NICN/EN/63/2013, between Comrade E.A. Ade and two others versus Mr. Uti Jof and 7 others, dated 17th February 2013, wherein a consent judgment was entered by the court on the 15th of January 2014, that the High Court of Delta State had earlier on in a similar suit, that is suit number AG/45/2002, that's Conference of Secondary School Tutor, and 3 others versus Professor Pat Mobogare and 2 others, granted a consent judgment in a similar suit, dated 17th December 2013, and filed on 19th December 2013, with similar terms of settlement in suit number NIC/EN/63/2013. In Melantaki versus Tongo and others, the Apex Court heard per ECHO, HMB ECHO, JSC, at pages 23 to 25, paragraph GA, on what forum shopping denotes, thus, quote, the decision to file this suit in the FCT far away from Gombe State, where the course of action arose, cannot be anything but a shared decision to abuse the judicial process. It was a decision to actuate forum shopping. It is a species of abuse of judicial process. Forum shopping denotes a rather reprehensible practice of choosing the most favorable territorial jurisdiction or court in which a matter or cause may be entertained and adjudicated upon.
On the matter.
Typical example of forum shopping, according to Black's Law Dictionary, is where the plaintiff institutes a suit in the jurisdiction with a reputation for awarding high damages, disdain for political gimmicks, or filing several similar suits and keeping the one with the preferred judge. See also Idemuda versus Benedion University, Okada, and others. Citation is in the judgment. The instant appellant, as the plaintiff had artfully avoided the High Court of Gombe State in preference to the FCT High Court because the former, as it appears, may be a forum inconvenience. I say no more. The dictum of Ogundare JSC, which I had earlier reproduced, should be sufficient to put their lordships of the FCT High Court on the watch out or guard so that their courts will be turned into axis of forum shopping, close of quote. The absurdity of it all is the placement of suit number NICN EN/63/2013, that is Comrade EA Ade, and two others with Mr. Uti, Geoff, and 7 others dated 17th February 2013 and suit number AG 45/2002 Conference of Secondary School Tutor, COSST, and 3 others with Professor Patrick Mabugari and 2 others, both of which granted consent judgments with similar terms of settlement. The law is firmly established that a court cannot subject the judgment of another court of coordinate.
Sorry, he said the voice is too loud. That should.
Who is talking like that?
Proceedings.
Who is talking there? Who is talking there? Madu Abuchi, I will cite you for contempt.
I'm sorry, my lord.
You don't know that you are before the court.
I'm so sorry, my lord.
So don't be talking in court like that now. You're interrupting what I am doing, and it's wrong. The law is firmly established that a court cannot subject the judgment of another court of coordinate jurisdiction or that of a superior court to interpretation or review. See Race Auto Supply Company Limited and others, Salaji Aki. See Dingadi versus ENEC and Dayson Holdings Limited versus BFI Group Corporation. The circumstance, it is my determination that suit number AG/45/2002 COSST and 3 others versus Professor Patrick Mabogare and 2 others shall not be subjected to interpretation or review by this court or at all, and I so hold. In support of notice of preliminary objection, the first and second defendants submitted that the first defendant, being an unregistered body, is not known to law, and cannot sue or be sued in its unregistered name, and such defects cannot be cured by amendment. Hence, the only reasonable thing to do is to strike out this suit. Cited Dwana versus Ibrahim and others, Maersk Line and another versus Adide Investment Limited and another, Dairo and others versus the registered trustees of the Anglican Diocese of Lagos. The citation in the judgment. And that is per Galinje, JSC, who said that, quote, where an association of persons is unincorporated, it does not have the legal status of a juristic person. Consequently, it can sue only by a representative action. Likewise, any person who has been wronged by such an association of persons can only sue it by suing some of its members as representatives of their association. See Fawemi versus NBA number 2. Abakaliki Local Government Council versus Abakaliki RMO. The citations is in the quotation. A cursory examination of the processes filed in this suit indicates that it was filed by the Nigerian Union of Teachers, Delta State Wing, and 5 others against Academic Staff Union of Secondary School, Delta State Chapter, also known as COST, COSST, and 3 others. In paragraph 2 of the affidavit in support of the preliminary objection, Comrade K.O. Oko, secondary school teacher, second defendant in this suit, and by virtue of which he is very conversant with the facts of this case, stated that he has the authority and consent of the first defendant, that is ASUS, also known as COSST, to depose to this affidavit. First and second defendant submission that suing first defendant is a defect that cannot be cured by amendment or at all, and as such, the entire suit is struck out by the authority of Dairo and others versus the registered trustees of the Anglican Diocese of Lagos, Supra. And in my humble view, is not tenable, as the registered bodies were sued in a representative capacity, and as such, is not grantable. And I so hold. The argument of the first and second defendants that originating summons is not the method of commencing an action where there is substantial issues of facts and hostile proceedings, which can only be resolved by calling witnesses, as in the instant case, and so the suit is incompetent and liable to be struck out. This is not the law. The law is that pleadings should be ordered. His Lordship Suleiman Galadima, JSC, delivering the lead judgment in Suleiman Atago versus Mr. Ibiso Muche and others, explained the correct position of the law in this world, quoting Justice Galadima, JSC. The general principle of law, as I understand it, is that where the court comes to the conclusion that the action ought not to have been commenced by originating summons, it shall proceed to order pleadings. Where, however, nothing will be achieved by an order of exchange of pleadings, an order for pleadings will not be made. This is the current judicial thinking, as stated by the Supreme Court in Emezi versus Osuagu. The citation is in the quotation. So as first and second defendants can see, Oba Osumbade versus Oba Oyewumi and Osai versus Wakwa, which they cited and relied on, comes in only where nothing will be achieved by an order for exchange of pleadings, in which event an order of pleadings will not be made. In any event, the rules of this court are quite specific that, quote, where in the opinion of the court, a suit commenced by originating summons raises substantial issues and dispute of facts, the court shall not strike out the matter, but may order its conversion to complaint and direct the parties to file and exchange pleadings and conduct the trial of the case in accordance with the rules of the court governing trial. Close of quote. See Order 3, Rule 17, Sub Rule 2 of the NICN Rules 2017. See also Silvanus Eze versus University of Jos. The citation is in the judgment where His Lordship Rose Weiber, JSC, delivering the lead ruling, said, quote, so once a suit has been filed by originating summons and it becomes obvious that facts are in dispute or the proceedings are likely to be hostile, a writ of summons would be ordered. Close of quote. In paragraph 21E of the affidavit in support of notice of preliminary objection, the second defendant stated that he was informed by counsel to the first and second defendants, Simon Eze Ezenwa Esquire of Olaiwola Afolabi and Company, the lawyer personally handling this case, on 3rd February 2021 in their law firm, in their law office in Benin City at about 2 p.m. when third defendant went there, for further briefing. The second defendant verily believed learned counsel that in view of the conflict of facts in the affidavit evidence of the parties and the fact that the case of the claimants is substantially based on issues of facts, originating summons is not the appropriate way to commence such an action. Second defendant did not specify paragraphs of the affidavit in support of the originating summons as the paragraphs containing contentious and disputable facts requiring oral testimony. By Akintokun versus Legal Practitioners Disciplinary Committee of the affidavit, Mohammed JSC said, quote, "It is not the duty of this court to go out of its way to fish out facts. Bodgson's PLC versus Calio at page 2407 and 2408. Abubakar versus Yaradua, citation is there. Even if there is any omission, it is not the duty of this court to fill in the gap or correct that omission. It must be noted, as heard by this court in Olapade, Samuel, Olatunwo, Unyebola, and others versus FAAN, that, quote, the interpretation of documents is not the function of a witness. It is a function of law meant for the court. I am satisfied after a look at the questions the claimants posed for determination that this suit was appropriately commenced using the originating summons procedure. Accordingly, I hold that the suit is competent. As such, this court has jurisdiction over it. The claimant's case is hinged on the interpretation of the consent judgment entered into by both parties in this suit in paragraph 13, Exhibit D and E of the claimant's affidavit in support of originating summons. Exhibit D deals with terms of settlement. The terms of settlement are as follows. The parties adopted the terms of settlement as consent judgment in this suit, and same was duly endorsed by Comrade J.O. Jamire Idigbe, that is the state chairman of NUT, Comrade Uti Geoff Chooks, state chairman COSST/ASUS, Elder Joe Iyale Kebwe, Principal Assistant Secretary, General NUT Delta State, Comrade Uho Faria, AC, the State Secretary, EOSST and ASUS, Pastor J.M.O. Nwabuoku, Counsel to Claimants, Barrister A.O. Ewere, counsel to ASUS, A.O. Odum Esquire, Special Advisor on Legal Matters, Barrister Charles O. Agbabu, Ministry of Justice, General's Chambers, Mr. Omamofo, S.A., Director, Office of Head of Service, representing Head of Service, Mr. Kim Oyewa, I.J.E., Acting Permanent Secretary, Ministry of Basic and Secondary Education, Comrade Mike Arinze, Chairman, Trade Union Congress, Barrister Moses Agwere, Ministry of Justice, Eguriase Abos, representing Chairman, SCSM. On the seven reliefs claimed by the claimants, 4 are declaratory, and proof of declaratory reliefs is very strict and must be on the strength of the claimant's evidence, not the weakness of the defense. C. Adamu versus Nigerian Air Force and another. River State versus AG River State versus AG Federation and another. Okon and others versus Samson and another. And Stella Oko, the Senate, versus Nawoj, Nigerian Association of Women Journalists, and 4 others. The citations are in the judgment. Adama and others versus Kogi State, House of Assembly, and others, citation is in the judgment, relied on International Textile Industries Nigeria Limited versus Dr. A.O. Aderemi and others, per Uwaifo JSC, in saying that a declaratory relief is merely a confirmation of what is likely to be in the state of affairs or what is likely to be in connection with the subject matter of the declaration. In other words, a declaration claimed must relate to some legal right, to a legal interest of which the law will take cognizance. A plaintiff who seeks a declaratory relief must show that he has an interest or right which forms a foundation for that declaration. See also Mr. Obidike and others, versus Minister of Lands, Housing and Urban Development and others. The burden of proof on the claimants is one that is strict and high. And by Dumes Nigeria Limited versus Wankoba, the Apex Court held that the burden is quite heavy in the sense that declaratory reliefs are not granted even on admission by the defendant where the plaintiff fails to establish his entitlement to the declaration by his own evidence. A declaratory relief cannot be granted in the absence of any evidence or where the evidence led is unsatisfactory. For that, see UBA PLC versus Signa Sabithos, Nigeria Limited. See also Maram and others versus Daniel and another. Thiararume and another versus Enoch and others. And Tazo versus Ure and others. The citations are in the judgment. The first question before this court is whether the first defendant is entitled to fix and collect levies from all secondary school teachers in Delta State for the running of Academic Staff Union of Secondary Schools, also known as COSST, which is not registered as a trade union in Nigeria. Only the interpretation of suit number NICN/EN 63/2013 can give us an answer. As I said earlier, as for suit number AG/45/2002, I reiterate that the law is firmly established that a court cannot subject the judgment of another court of coordinate jurisdiction or that of a superior court to interpretation or review. There are cited cases in the judgment to that effect. The contention of the claimants in this case is that by the combined and community reading of Article 4, Sub 1 of the NUT Constitution as amended 2014, the preamble of the COSST Constitution and paragraphs 1, 2, 3, and 4 of the consent judgment and orders that the first defendant is not entitled to fix and collect levies from all secondary school teachers in Delta State for the running of our association, not being a registered trade union in Nigeria. That the first defendant is only an association and cannot be accorded the rights and privileges of a trade union. To the first and second defendants, it is submitted that the claimants, having considered that the issue of deduction of levies on behalf of the first defendant was the mistake of the computer center, and the same matter has been resolved, wherein the computer center and the same matter has been resolved, wherein the computer center directed to make future deduction for the first defendant bear on the list of the members supplied to them by the first defendant, it amounts to an abuse of court process for the claimants to file this suit based on the same issue that has been resolved. That abuse of process of court consists of an improper use of issue of judicial process or process already issued to the irritation or annoyance of the opponent. That equally amounting to abuse to institute an action during the pendency of another one claiming the same release. The cited cases there to that effect. Nya versus Noah, Shodikpo versus Lemi, Kanyip, and another, Saraki versus Kotoye. The cases authority is as in the judgment. First and second defendants submitted further that this suit is brought in bad faith, and where abuse of process is adjudged, like the instant case, a court worth its salt must be ready to prevent the improper use of its machinery. That the issue, number one, raised by the claimant is an academic exercise, as the first defendant was not insisting on deduction based on general payroll of the teachers only supply the computer center the list of its members, which deduction can be made on its behalf. The claimants admitted that it was agreed that further deductions is to be made based on the first defendant's list of members. That there is nothing before this court to show that the first and second defendants violate the amicable settlement. Paragraph 86 above clearly indicates that the claimants and counsel representing the claimants duly endorsed the terms of settlement copiously narrated in paragraph 85 of this judgment by Umar Mohammed Nasco and another versus Abubakar Sani Bello and others. Pel Abaji, JSC. Supreme Court heard, and I quote, a party cannot approbate or reprobate at the same time. One cannot eat his cake and have it back again. In other words, can the law permit him to blow hot and cold at the same time? Or can he approbate and reprobate? See also per Mohammed JSC in Yako versus Adamawa State House of Assembly, and others, close of quote. And the United Bank for Africa PLC versus Mr. Sunday Udusip, Augie, JCA, now JSC, retired, at pages 27 to 30, paragraphs F to D, said, quoting Justice Augie, JSC, retired. In effect, unincorporated and non-juristic entities are associations of persons who do not possess a personality different and distinct from its members. See Fawemi versus NBA number 2 Supra, wherein Caribe White, JSC, observed that, quote, the right to form any association for the protection of the interest of the members is an entrenched right. Thus, an association of persons recognized by Section 37 is a lawful association, simpliciter. Our law seems to me to endorse the proposition that no association of any kind could be formed without being authorized by the state. In the same Fawemi versus NBA number 2 Supra, Obaseki JSC also observed, quote, the name Nigerian Bar Association is not a registered name under any statute, although it is recognized and accepted as the name of the body by various statutes. The NBA loses nothing by being declared a non-juristic person. It can always sue and be sued in a representative capacity. Representative action is always available to it and to all persons wronged by it, close of quote. So aside the ipse dixit of the claimants that the first defendant is not a registered trade union, but only an association and cannot be accorded the right privileges of a trade union, there is no legal basis to sustain the claimant's arguments whatsoever, and I so hold. The claimant submitted that by the combined and community reading of Article 4, Sub 1 of the NUT Constitution as amended in 2014, and the preamble of COSST Constitution, that is Exhibit A and B, and paragraphs 1, 2, 3, and 4, the first defendant is not entitled to fix and collect levies from all secondary school teachers in Delta State, running of her association. The claimant woefully failed to tell the court. Who is talking like that?
Stephen Williams.
Hmm?
Stephen Williams.
Where is he? See him, man.
Yes, ma'am.
Who is Stephen Williams? Stephen Williams, you're making noise. I will cite you for contempt. Stephen Williams, be careful. Tell Stephen Williams if he keeps making noise, I will cite him for contempt of court. I mark him. Let him not disrupt the court. Where was I? The claimants, let me continue now. The claimants woefully failed, as I was saying, the claimants woefully failed to tell the court what their community reading of NUT Constitution and the exhibits cited by the claimants revealed to enable the court to make a determination of question 1. Article 4.1 of the NUT Constitution 2014 state that every teacher in the employment of federal, state, local government, and any other approved educational institution shall be a member of the union. Article 4 of COSST states that regional officers of COSST of the first defendant shall be elected officers who must emerge from election of state delegates. Exhibit C is the terms of settlement. It states in paragraph 4, thus, at the meeting of December 2013, the parties came to a compromise and agreed to a peaceful settlement of all issues between the parties in the overall interest of the education system in Delta State. Close of quote. Oxford Dictionary, 9th edition, at page 326, defines the word compromise as, quote, an agreement between two or more persons to settle matters in dispute between them. An agreement for the settlement of a real or supposed claim. Or supposed claim. A settlement that becomes a court judgment. Where were we? A supposed claim in which each party surrenders something. An agreed judgment, 9th edition at page 918, is a settlement that becomes a court judgment when the judge sanctions it. In effect, an agreed judgment is merely a contract acknowledged in open court and ordered to be recorded, but it binds the parties as fully as other judgments. Also termed consent judgment, stipulated judgment, judgment by consent, close of quote. On whether parties are at liberty to compromise or settle the terms of a court judgment, the Apex Court heard in Minaj Holdings Limited versus Comptroller General of Nigerian Customs Service and others, per Augie, JSC, that, quote, it is settled as this court, per Oguntade JSC, observed in SPM Limited versus Adetunji and others, that, quote, it is the role of the judex in adjudication to encourage amicable settlement where it can adequately meet and satisfy the end of justice. The court has a discretionary jurisdiction to examine the entire circumstances of a case in order to determine whether the alleged terms of settlement, which to all intents and purposes are compromise agreement, entered into by the parties, should be scrutinized and made an order of court. When terms of settlement, or other words, compromise agreement, becomes an order of court, it, in legal parlance, becomes consent judgment. A compromise settlement between parties to a dispute may be described as a contract whereby new rights are created between them in substitution for and in consideration of the abandonment of the claim or claims pending before the court. A consent judgment or order by nature is as effective in law in respect of all the matters which are settled as any other judgment or order arrived at after hearing a matter on merit. The essence is to put a stop to litigation between the parties, just as much as a judgment which results in the normal proceedings of a court in a matter heard on its merits, close of quote. Article 4:1 of the NUT Constitution states that every teacher in the employment of federal, state, local government, and other approved educational institutions shall be a member of the union. Wait a minute.
Welcome.
The preamble to the Constitution of Conference of Secondary School Tutors, COSST Nigeria, states that being mindful of the benefits we deserve by coming together as secondary school teachers, being lawful citizens of Nigeria and loyal members of the NUT, do agree to come together to constitute a conference that will embrace all secondary school tutors in Nigeria and do hereby give ourselves this constitution. Exhibit C is the terms of settlement in unreported suit number NIC EN 63/2013 between Comrade E.A. Ade and two others versus Mr. Uti Gio and 7 others. Judgment of which delivered on 24th February 2014. It is well settled that the preamble to a statute or written document is merely an introductory part of it. It is therefore not a part of the statute or written document. See Obona versus Attorney General Imo State and others. See also Chairman, Lagos Executive Development Board versus Said and others. See Gasali versus FRN. Claimants submitted that the first defendant is not entitled to fix and collect levies from all secondary school teachers in Delta State for the running of our association. Not as a registered trade union in Nigeria, that not all secondary school are members of our association, only a few claim to be, and that the consent judgment did not permit the first defendant to fix and collect levies from the secondary school teachers' salaries. The terms of settlement in suit number NICM/EN/63/2013 clearly states in terms B and D that B, upon the registration of the first claimant as a trade union, the check-off dues of all the teachers in secondary schools in Delta State shall be deducted and paid to the first claimant. D, the first claimant or ASUS shall be entitled to fix and collect levies from her members for the running of the association. Office of the head of service shall assist the first claimant or ASUS to collect such levies. These terms of settlement are what would expectedly happen or be done by the parties as a raison d'etre of the judgment. The arguments of the claimant are rather tendentious. They are a crass distortion of the terms of settlement. The consent judgment in suit number NICM/EN/63/2013 did not state in any of the 4 terms of settlement that the first defendant is entitled to fix and collect levies from all secondary school teachers in Delta State for the running of academic staff union of secondary school, also known as ASUS, and I so hold. Question 2 is whether first defendant, not being a registered trade union, being a bona fide member of the NUT, Delta State wing, can solely willfully and unilaterally compile and convey a list of their alleged members to the office of the head of service, Delta State, without the list first being seen, verified, and authenticated by the first claimant. It is submitted by the claimant that ASUS is not a registered trade union, that the strength of membership of first defendant in Delta State is unascertainable, that the first defendant being a subscribing member of the first claimant compiled a list of its alleged members and submitted it to the fifth defendant without the list being verified and authenticated by the first claimant. That claimants that the office of the fifth defendant collected the said list without any recourse to the claimants for verification and ascertainment, and forwarded them to the Accountant General's office. That many secondary school teachers whose names deceitfully appeared on the list did not give their consent and approval. Question 3, substantially similar to question 2, will be taken together with question 2. The arguments of the claimant on the issue raised in question 2 and 3 utterly missed the point of the law. The argument of the claimants on the issues raised in questions 2 and 3 utterly missed the position of the law on the said issues. In the case of executive chairman and management of Benue State Universal Basic Education Board, that is SUBEB, versus non-academic staff union, NASU, the Court of Appeal heard per Afen, JCA, at pages 63 to 65, that, quote, because the right enshrined in Section 40 of the 1999 Constitution of the Federal Republic of Nigeria is not absolute, but a qualified right that is subject to the derogation set out in Section 45, sub 1 thereof. The right of members of SUBEB's non-academic staff to join or out of a trade union can only be exercised within the ambit of and in the manner provided by law. Deduction, payment of check-off dues are necessary incidents of trade union, but it would seem this is based not on membership of a trade union per se, but on eligibility to be a member of such a trade union. An employer can compulsorily make the deduction and remit them to the relevant trade union listed in Part A of the third schedule of the Trade Union Act without the consent of the employee. See the case of UDO versus Orthopedic Hospital Management Board. The citation is in the judgment. Vuntade APA, as it then was. So the argument of the claimant that it is an aberration for the first defendant to forward to the Accountant General's office and the computer center data state a deceitful attendance list or sheet, and that the first defendant cannot run its association but subsume into the first claimant, in my humble view, is anachronistic. It is unsustainable. It is unconstitutional, and I so hold. In questions 4 and 5, it is submitted by the claimants that it is inappropriate and irregular for the fifth defendant's office to collect and send a list compiled by the first defendant to the office of the Accountant General, data state, without recourse to the first claimants, being the parent body of all the teachers for verification and authentication. I must bring the big. On question 4 and 5, it is submitted by the claimant that it is inappropriate and irregular for the fifth defendant's office to collect and send the list compiled by the first defendant to the office of the Accountant General, data state, without recourse to the first claimant, being the parent body of all teachers for verification and authentication, that the Accountant General cannot endorse the alleged list of first defendant member to the computer center without verification from the first claimant for accuracy, that the submission of the entire payroll of the entire post-primary education board that the submission of the entire payroll of the entire post-primary education board teaching and non-teaching staff by the first and second defendant On request for a soft copy of the computer center from where a levy of the sum of 500 naira was deducted from the February salaries of about 1,450 PPEB staff is completely an infraction, an illegality, novel, too overbearing, therefore null and void. That many secondary school teachers whose names deceitfully appeared on the list did not give their consent and approval. That paragraph 4 of the consent judgment never referred to deduction of monies and teachers' salaries. That to do so is clearly an aberration. Question 6 is exponential. What is that? Question 6 is exponential. Who is that? Question 6 is exponentially in sync with questions 4 and 5 and will be taken together. See, Obiawe versus Integrated Rubber Production, Nigeria Limited, and another. Owena Bank, Nigeria PLC versus NCE. That the consent judgment and the NUT constitution, including COSST constitution, are clear and unambiguous. Where a statute has made clear provisions, it would be wrong for anybody, not even a court of law, to give a contrary interpretation. Cited Nigerian Army Brigadier General Aminu Kano. Claimant submitted Brigadier General Nigerian Army versus Brigadier General Aminu Kano. Also cited Balonwu versus Governor Anambra State. The claimant submitted in question 7 that the first defendant, not being a registered trade union, cannot willfully, unilaterally, and surreptitiously collect monthly levies or dues to make deductions from the salaries of secondary school teachers in Delta State who are duly registered members of the first and sixth claimants, a trade union, that it is illegal to do so. The arguments of the claimants on question 7 are entirely in tandem with the arguments in question 1 to 6 of the claimant's written address in support of the originating summons. In reaction, the first and second defendants submitted that the claimants, not being members of the first defendant and not having been given the power to see, verify, and authenticate list of the first defendant's members, claimants lack the local standard to challenge the first defendant's list of members, and this court lacks the jurisdiction to entertain this matter on that ground. Cited Sheep Cow versus AG Zamfara State. Yasufu versus Governor of Edo State and others. And other cases cited. The first and second defendants argued further that the claimants are very much aware that the first defendant is an unregistered body shown in the consent judgment. The claimants cannot file this suit, that the claimant cannot file this suit and ask the court to restrain the first defendant from collecting levies from its members, because it is not registered to do so will amount giving back to the original course of action that has been compromised by the parties. Cited Abe and others versus Comrade Sam Do. Race Auto Supply Company Limited and others versus Alaji. Pausat Akib Debayo versus Olajubun. Citations are in the judgment. For the first and second defendants, the claimants attempt to use the constitution of COSST against the first defendant is unacceptable. That the first defendant as a body has its own constitution which regulates its affairs, and not the constitution of COSST, which is now defunct. That it is ridiculous for the claimants to demand to see, verify, and authenticate list of an association members when they themselves are not members of COSST. That this suit is frivolous and vexatious and should be dismissed with substantial cost. What is clear and evident is that all the reliefs prayed for by the claimants in the instant case are covered by the order/terms of settlement in suit number NICN/EN/63/2017. That is, the title to fix and collect levies from secondary school teachers in Delta State, whether it is appropriate for the head of Delta State to collect the list from the first defendant to the office of the head of service without clarification from first claimant etc. The instant case is accordingly an attempt by the claimants to relitigate issues already entered as constant judgment by all the parties. On whether a judgment of court in a trade dispute can be enforced against a person who was not a party in the proceedings, the Court of Appeal, in the case of Independent National Electoral Commission, that is INEC, versus Association of Senior Civil Servants of Nigeria, and another, heard per Peter Odili, JCA, as she then was, at pages 24 to 32, paragraphs F and E, thus: it is of general application that the court cannot give a judgment against a person who will be affected by its decision if such a person is not made a party has no opportunity of defending the suit. This is because the court has no jurisdiction to decide the fate of a person or matter concerning him when such a person is not made a party to the act. I refer to Babatola versus Ladejana. The citation is in the judgment. The Trade Dispute Amendment Decree number 47, 1992, specifically ousts the jurisdiction of the High Court in all matters of trade disputes and inter- and intra-union disputes as prescribed by the Trade Disputes Act as amended by the Trade Dispute Amendment Decree number 47 of 1992, Apena versus NPPP. Under the provisions of Section 1A, Sub 1 of the Trade Disputes Amendment Decree number 47 of 1992, it is the National Industrial Court that has exclusive jurisdiction to hear and determine all matters relating to trade disputes and inter- and intra-union disputes. In Awoni versus Registered Trustees of Kanyip, persons against whom complaints are made in an action must be made parties to such actions. See Uzo versus Nigerian Stores Workers Union. Citation is in the judgment. In civil actions, all parties necessary for the invocation of the judicial power of the court must come before it so as to give the court jurisdiction to grant the reliefs sought. See the case of Oloride versus Oyebi and Okafo versus Waife. This court, under Section 7, 1C to 3 of the NSC Act 2006 and Section 254C1 1J, 4, and 5 of the 1999 Constitution as amended, respectively, has jurisdiction over the determination of any question as to the interpretation and application of the terms of settlement of any labor dispute, organization, dispute, as may be recorded in any memorandum of settlement. Any terms of settlement of any trade dispute and any trade union dispute or employment dispute as may be recorded in a memorandum of settlement, close of quote. Claimants are not in this court for the interpretation of the terms of settlement and wrote consent judgment in suit number NICN/EN/63/2013, but have filed a new suit seeking indirectly to relitigate issues that a court of competent jurisdiction has resolved by the authority of INEC versus Association of Senior Civil Servants of Nigeria and another, SUPRA, suit number AG/45/2002, the High Court of Delta State should not have been filed there at all 10 years after Decree number 47 of 1992. If the claimants have any problem with the enrolled order entered in suit number NIC/EN/63/2013, their recourse is to the Court of Appeal, not this court. That the reliefs sought dealing with first defendant not registered as a trade union in Nigeria were brought into the fray. The instant case is nothing but to give the case a semblance of independence and separateness from suit number NIC/EN/63/2013, just so that this court may be seen to be vested with immediate jurisdiction. That is sad. On the whole, it is my determination that the instant case is an attempt to re-litigating issues already settled in suit number NIC/EN/63/2013. Questions 1, 2, 3, 4, 5, 6, and 7 are all answered against the claimant. For all the reasons given, the reliefs claimed by the claimants must fail as against the claimants. I find no merit in this action as far as the claimants are concerned. It fails, and so is hereby dismissed with 100,000 naira cost to the first and second defendants.
That's your court, please.
Entered accordingly.
That's your court, please. I know what it depends on. What's I'm saying? Don't you know all the data about it? Life move. Life move.
That will be all. The court will write.
God, I say. I remember our best. Benin, comedy. Paris, congratulations.
Hello, congratulations.
Paris,
how are you? Hello. Congratulations, congratulations. Yes, I'm
We
here.
defeated them.
Oh, congratulations.
Congratulations. Congratulations. All passes. All passes.
Forward ever.
Backward never.
Yes, sir.
Forward
Yes,
never.
sir.
Congratulations.
Congratulations, sir.
We thank God.
We thank God, sir.
I know what power. That's what's that. Oh no, oh no,
Well
you
done.
I want very. They are stupid people. They will continue to lose.
Yes, they will.
I am not calling that. I have to say anything. Anything local to us is not. I'm just a lot more life more. When anyone on us will be come out for this loan that I'm not follow. I'm to our local. No, they are stupid. You know what?
Thank you, Lord. Thank you, Lord. All right, bye.